So you might be wondering, what are some of the common mistakes I see people make when they've tried to file their own trademark application or had even an inexperienced attorney try to file a trademark application for them? The first big mistake I see trademark applicants make in their own applications is that they confuse the thing they're registering with the universe of stuff they're selling. Just as an example, say a trademark applicant will come to me, they've already filed their application, so I'm getting it as they prepared it, and they will list a specific thing they sell, say a belt for as an accessory. So I sell leather belts. But then when you go to their website, they sell leather belts, shirts, shoes, all kinds of accessories. And then when I do the trademark search, we discover that that brand name has been used for decades and is registered for making hats. Well, maybe that registration was going to go through for the single item of belts, but by using that brand name, this particular business would be in a bundle of trouble for other accessories. So don't confuse the registration itself with the thing you sell. Another mistake I see businesses make, they will submit what's called a description of goods and services that is a mile long. I call this the legal quickie mistake, because you can take a description of a category of goods and services and by checking a box declare that you are intending to use or actually selling goods and services with a mark that cover 1,000 different things. So every hat, shoes, belts, belt buckles, socks, you name it, right? But then you go to their website and they only sell boots. Well, this is an overbroad trademark application. You are begging to fight trademark cancellation proceedings and trademark invalidation proceedings if you do this, because someone else might want to use a similar brand name and a trademark examiner might cite your registration against them, and the only way they have to receive their registration is to cancel yours. So an overbroad, in other words, asking for too many things in your trademark application, is a surefire way to end up fighting legal proceedings you just don't have the budget or even need for fighting in the future. Another big mistake I've seen people make is that they file a trademark application without doing a full trademark search first. This is, to me, Trademark 101. You must understand the context and the constellation of marks that exist before you can determine where your particular branding fits within this universe of other brands. It's just how the trademark system works. What is the corner of the universe that you are claiming exclusivity in? Well, you don't even know what the universe looks like without a full trademark search first. So always, always, always get a full trademark search with a report that you review in consultation with your attorney before filing a trademark application. Which leads to the next big mistake, and that's trying to do it yourself or file a trademark application without consulting with a trademark attorney. Experience matters. If you try to wire your own home, you might be in for a shock, and in more than one way. Professionals have businesses, they have professions because they're good at what they do. So whether it's an electrician or a plumber or a home contractor, experts earn the money they do because they provide a service in a level of skill that would take you years and decades to develop. It's true in trademark law as well. Consult with a trademark attorney. Let their years of experience become your experience by paying them a few bucks. It will save you much more money and years of headache in the future. Another big mistake that trademark applicants make is they think that by filing an LLC paper or an incorporation paper that they're also getting a trademark registered. And just no. They're two different things. Secretary of State's offices have two different offices staffed by two different groups of people, often in different buildings. These are not the same thing. They're entirely different. Trademark applications and branding are their own universe. Incorporations and maintaining them are their own universe. Don't get those confused. Another mistake that trademark applicants make is confusing the sample of their product that's submitted with their application with the mark itself. Sometimes an applicant will submit their product under the section where they're submitting their mark, and they don't, because it's not the mark as it's required to be presented to the trademark office. Quick detail: the trademark office requires that you submit your mark as either stylized or standard letter characters. And if you do it as stylized, it must be or should be in the particular font that you're claiming. So if you submit a product image with your mark on it, it's not the image of the mark that the trademark office is expecting. You'll get a rejection that's very difficult to overcome, and we might have to start back at the beginning. Don't make that mistake. Another common mistake is when applicants will send in a single sample of their product being sold or their service being provided with the mark on it. I like submitting 3 samples for my clients that are each individually distinct. That way, if an examiner has an issue with or doesn't like one particular sample, we have more that we can point to. The product sample is evidence, and so submitting different samples of evidence, as long as you're not what we call voluminous, is frequently viewed favorably by the trademark examiner themselves. Another big mistake that I see applicants make all the time is confusing the descriptions that are required in the trademark application, or worse, using the same description for all 3 descriptions that are required. There's a description of your mark, especially if it's stylized or includes a logo with it. One description is of the mark itself. So for example, let's say that the mark is Starbucks and it's in a script format. Then the description of the mark is the word Starbucks in a script format, and you would call out the specific font. That's a description of the mark. A description of the sample is a different description. Continuing with Starbucks, it is a cup of coffee with the logo thereon. Right? That's also different from the items sold or the services provided. That's a separate description. In this case, for Starbucks, coffee. So the 3 descriptions are for 3 different things and should reflect what they're asking for. But I see this mistake made all the time. Another mistake I see applicants make in their trademark applications is that they submit an application using a sample of a product sold without the mark on it at all. Why? But it happens. Now, the last mistake we'll discuss is another common mistake, most often in the context of an application to reserve a mark, where the sample that's submitted has a mark on it that looks a little bit different from the mark that was applied for originally. So this is a common mistake in applications that are prepared by individuals and inexperienced attorneys. They'll apply for a mark where a designer provides them with an initial logo design or branding design. The application goes through an examination process, becomes an allowed application, and then you have to submit the sample. Well, in that intervening 6 to 9 months, frequently the designer or the business owner falls in love with a little bit different font or wants to change the logo just a little bit, maybe change the color a little or put a star on it or something. And that change makes it a different logo in the eyes of the trademark office. So guess what? If the sample that's submitted to the trademark office looks differently than the original mark as it was originally submitted, they're different. And so the trademark office examiner will ignore that sample. That's another common mistake. And frequently, when applicants come to me and they don't understand what's going on because they think that they've submitted 3 and 4 and 5 samples of their mark in use in commerce, all I have to do is open up that application and go to the first page, and what I see is a different mark, and it's just like, oh man, here we go again. So don't make any of these mistakes. Hire an attorney to help.